Given that the weather hasn't been cooperating with us so far this semester, I've decided to film some of the lectures to ensure that we stay on schedule. This video will complete the material in section 1.2. The reading assigned for section 1.2 links to the Bureau of Justice Statistics website. However, the information provided there parallels the information in the loud cloud text for section 1.2 titled The Criminal Justice Process, page 5 through 9. To begin, this figure is an illustration of an offender's pathway through the criminal justice system, showing the beginning of the process to the very end. Despite its complicated appearance, this figure is actually a simplified view. This lecture will break down all of the steps into smaller parts. We'll begin with the overall police component of the criminal justice system. For the beginning of the criminal justice process to begin, a crime must be known to police. Interestingly, most crimes are not known to police. Only about 40% of victims of violent and property crimes report their victimization. Additionally, some crimes don't have victims, and some crimes don't have witnesses. In total, it is estimated that police really only know about 3% of all crimes. The crimes that are unknown to police are termed the dark figure of crime. Once law enforcement is aware that a crime has occurred, the first step in criminal case processing is investigation. This phase involves several activities, such as gathering evidence, interviewing witnesses, and pursuing suspects. Not surprisingly, for the process to continue further into the criminal justice system, a suspect has to be identified and arrested. After a suspect is arrested or taken into custody to be charged with a crime, the process moves to the courts component of the criminal justice system. We will now cover the pretrial activities, including an initial appearance, preliminary hearing or grand jury, information or indictment, and arraignment. For official charges of a crime to be filed, a prosecutor has to assess whether there is probable cause. Probable cause essentially means that information exists that would lead a reasonable person to believe that a person committed the crime or was planning to commit the crime, depending on the charges. In assessing the case for probable cause, the prosecutor decides if formal charges will be filed or dropped. If there isn't strong evidence, cases can be dropped. If charges are filed by the prosecutor, a judge then assesses the case. At the initial appearance, a judge informs the defendant, or the person being charged with the crime, of the charges. Additionally, at the initial appearance, a judge will assess whether the person should be held for pretrial detention. Pretrial detention or detainment means that an offender can be incarcerated prior to being convicted of a crime. And for lower offenses, a judge may determine guilt and assess a penalty here at the initial appearance. If the case outcome is not addressed at the initial appearance stage, a judge or a jury decides whether it should go to trial. In a preliminary hearing, a judge assesses for probable cause and decides if there is enough evidence for it to go to trial. With a grand jury, a jury is deciding if there is enough evidence for the case to go to trial. During a grand jury trial and the preliminary hearing, the jury or the judge is not assessing guilt. The jury or the judge is only listening to the facts presented by the prosecution and determining whether probable cause is sufficient. A grand jury can be used when a person waives the right to a preliminary hearing. In a preliminary hearing, if a judge decides there is probable cause, the prosecutor can file the official charges, which is referred to as filing an information. In a grand jury, if the jury decides there is enough probable cause, the jury will file official charges, which is referred to an indictment. And that is listed here on the top of the slide. So, when a judge assesses the case through the preliminary hearing, the prosecutor files an information. When a grand jury assesses the case through a grand jury trial, the jury can file the charges through an indictment. If the case hasn't been dropped and formal charges have been filed, the case moves to arraignment. During arraignment, the judge informs the defendant or suspect of the charges filed against them. The defendant has to enter a plea at this stage. The plea options are pleading guilty, admitting guilt, pleading not guilty, or not admitting guilt, or pleading no contest, or accepting punishment but not admitting guilt. Pleas of guilty or no contest waive the right of a trial. Most cases, 95%, do not go to trial. If the defendant pleads guilty or no contest, sentencing can occur through plea bargaining or the judge determines the sentence. Plea bargaining is when the prosecutor and defense work together to agree upon a sentence. We will talk more about this process later in the semester. In cases where the defendant pleads not guilty, the case proceeds to trial. This signals the adjudication phase of the criminal justice system. Adjudication is the point at which a case goes to trial with the purpose of coming up with a resolution to the case. Again, less than 5% of cases actually end up going to trial. Trial options include a bench trial or a jury trial. In a bench trial, or trial by judge, there is no jury involved. Only a judge assesses the case and determines guilt. One example of an infamous bench trial was with Ted Bundy in 1976 when he was charged with kidnapping and assault. He waived his right to a jury trial and instead elected for a bench trial. The judge convicted him. In contrast, a jury trial, or trial by jury, is when a jury assesses the case and determines guilt. The outcome of a bench or jury trial is the determination of guilt. If the defendant is acquitted, they have been found innocent or not guilty. If the defendant is convicted, they have been found guilty. We'll cover more details about the process of a trial later in the semester. If the defendant is convicted, the process moves to the sentencing phase. This is still in the court component of the criminal justice system. In the U.S., the types of punishments or sentences that can be imposed on someone convicted of a crime ranges from fines to capital punishment or death, depending on the crime, of course. In a sentencing hearing, the circumstances of the crime and the characteristics of the offender can be taken into account to determine the appropriate sentence. Mitigating circumstances reduce the offender's blame and generally reduce the severity of the penalty. Some mitigating circumstances would be if the offender is young and does not have a criminal record, for example. Aggravating factors, on the other hand, increase the offender's blame. Aggregating factors tend to increase the harshness of a penalty. For example, if the offender used a weapon and had a lengthy criminal record, those would be aggravating factors. In some cases, defendants appeal the outcome of the case, i.e. their guilt, or the sentence in a case. In appellate reviews, a higher court examines the arrest, trial, outcome, etc. In some cases, such as capital cases, i.e. death penalty cases, appeals are automatically granted. However, in other cases, higher courts have the option of choosing what appeals to review. After the sentencing stage, the entire process moves to the corrections component of the criminal justice system. Corrections is when the actual sentence is carried out. Later in the semester, we'll cover different types of sentences, and here we'll just briefly touch on the difference between someone being sentenced to incarceration in a jail or prison. Many folks use the terms jail and prison interchangeably, but that is incorrect. There are numerous differences between these facilities. Jails are facilities that generally hold people who are awaiting trial, haven't been convicted yet, or who are convicted of misdemeanors. In the next chapter, we'll go over which types of crimes fall under misdemeanors. For now, understand that misdemeanors are less serious crimes that generally have a maximum jail sentence of 1 year. Jails are also different from prisons because jails are operated by the local county. Additionally, jails hold men and women. In contrast, prisons are facilities that only hold people who are convicted. Inmates in prisons have usually been convicted of a felony, which is a more serious crime that carries a sentence of a minimum of a year in prison. Prisons are operated by the state or federal government, not the county. Additionally, prisons only hold one sex. That is, there are separate facilities for men and women. So these are important differences that you'll need to know. Again, we'll cover some more details on corrections later in the semester, but one additional thing I'd like to cover now is the difference between indeterminate and determinate sentences. For indeterminate sentences, offenders are sentenced to a range of time in a jail or prison, such as 25 years to life in prison. That is, when someone is sentenced to an indeterminate sentence, they do not know exactly how much time they'll spend incarcerated. Offenders who are sentenced with indeterminate sentences can be eligible for parole or release in supervision prior to their full sentence is up. We will discuss parole more later in the semester. On the other hand, Determinate sentences are when offenders are sentenced to a specific amount of time. Offenders who are handed down a determinate sentence know exactly how much time they'll serve, assuming that they don't get added time during their sentence for other charges or infractions. Determinate sentences do not offer the opportunity to be paroled. To summarize, this table illustrates the condensed steps in the criminal justice system process and outlines what component of the criminal justice system is involved in each step. In a nutshell, a crime occurs. This can lead law enforcement personnel to conduct an investigation and identify the suspect. Once someone is arrested, the case moves to the courts. Pretrial activities occur, including the prosecutor assessing the case for probable cause, the initial appearance, and then the preliminary hearing or grand jury. After that, if charges are officially filed, then arraignment occurs. After arraignment, the case enters the adjudication phase, which indicates the start of a bench or jury trial. If convicted, the case proceeds to sentencing. In some instances, cases will be reviewed through appellate review by a higher court. And assuming the verdict or sentence isn't overturned by the review, the offender proceeds to the corrections component of the system and carries out their imposed sentence. In a nutshell, that is generally the process of criminal cases as they move through the criminal justice system. This concludes section 1.2. In the next video, we'll cover section 3.1.